This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about the difficulties a person has when they lie on an insurance application, even an insurance application under the Employee Retirement Income Security Act, or ERISA. In the case that was recently decided, Plaintiff Bradley McKinney applied for and obtained a disability insurance policy with Plaintiff Provident Life Accident and Insurance Company. He made claim under ERISA, 29 U.S.C. Section 1001, etc. McKinney subsequently filed a claim for disability benefits under the policy, but Provident Life rejected his claim on the ground that McKinney made material misrepresentations in his application for the policy. Provident Life sued under ERISA seeking rescission of the insurance policy, and McKinney counterclaimed seeking an order directing Provident Life to pay him all benefits due under the policy. In Provident Life and Accident Insurance Company versus Bradley D. McKinney, a September 9, 2022 decision, the United States District Court for Connecticut resolved the dispute. The parties agreed on the following facts. McKinney's employer, Anderson Tax, LLC, maintained a supplemental individual disability insurance plan. 2. Relevant here, the plan permitted eligible employees to apply for a combination of 3 types of coverages: long-term disability benefits, which defendant refers to as guaranteed standard issue, and which the court will refer to as basic disability benefits, catastrophic disability coverage, and an option to convert the basic disability benefits into long-term coverage. 3. An employee could apply for any individual or combination of these coverages on the same form. McKinney applied for supplemental insurance for the plan. In completing the application, McKinney answered various questions about his medical history and agreed that his answers were true and complete and correctly recorded to the best of his knowledge and belief. In September of that year, Provident Life issued him an insurance policy providing all 3 coverages. The policy provided, however, that omissions and misstatements in the application could cause an otherwise valid claim to be denied or the policy to be rescinded. In August of 2018, McKinney filed a claim for basic disability benefits related to a neurocognitive disorder. He first began experiencing symptoms of confusion, severe fatigue, loss of memory, challenges with thinking, analyzing, and lack of concentration in February of 2016. Provident Life's claim specialist investigated McKinney's claim, obtained certain medical records, and consulted with underwriters. Thereafter, Provident Life denied McKinney's claim and notified him that it was rescinding its policy on the ground that McKinney had materially misrepresented his medical history when applying for the insurance. McKinney filed an appeal, and after obtaining more of his medical records, Provident Life concluded it had properly rescinded the policy. McKinney untruthfully represented his medical history on the application for insurance in 2 ways. 1. In answering questions 6 and 8, he represented he had not received diagnosis or treatment from a physician for memory loss, confusion, or speech disruption in the 5 years preceding his application. In answering question 3A, he represented he had not missed 1 or more days of work or been admitted to a medical facility due to sickness or injury in the 180 days preceding his application, and 2, upon reviewing McKinney's medical records, Provident Life concluded that his answers to those questions were untruthful and that its denial of his claim and rescission of his policy were proper. The parties do not dispute that a planned fiduciary may obtain equitable rescission of an ERISA-governed insurance policy that is procured through the material misstatements or omissions of an insured. Under the federal common law that is developed pursuant to ERISA, an insurer can rescind a policy where the insured knowingly made a material misrepresentation in an application for an ERISA-governed insurance policy. Thus, Provident Life will be and is entitled to summary judgment if it demonstrates that there is no genuine dispute that 1, McKinney made a misrepresentation, 2, he made it knowingly, and 3, that it was material to Provident's decision to issue the insurance policy. In the opinion of the court, Provident Life rejected McKinney's claim for basic disability benefits and subsequent appeal on the ground that he untruthfully represented his medical history on the application for insurance coverage. Provident Life identified 2 of McKinney's responses that were allegedly untrue, warranting rescission of the policy. The court found no genuine dispute of fact that McKinney made material misrepresentations in responding to questions 6 and 8 of his application for supplemental insurance coverage. McKinney contended that the primary condition for which he was treated during the 2016 hospitalization was cancer related to the mass on his chest, and that his confusion and speech disruption were merely symptoms of that cancer. McKinney also contended, however, that any misrepresentation in his responses were innocent because he was not aware that he had been diagnosed with or treated for memory loss, confusion, or speech issues. The court concluded, however, that any ignorance on McKinney's part that he had been treated for confusion and speech disruption during his 2016 hospitalization was not innocent. Indeed, when questioned in the course of his claim for benefits, he acknowledged that he was first diagnosed with these problems in February of 2016. The idea that he did not know about them when he applied for the insurance policy in 2017 therefore strained credulity. The U.S.C. concluded there was no genuine dispute that McKinney's untrue answers to questions 6 and 8 were material to Provident Life's issuance of the policy. Courts have repeatedly explained that certain information requested by an insurer and provided by the applicant for insurance coverage is presumptively material. The mere fact of asking the question proves that its answers were material to the decision of the insurer to insure or not insure. McKinney's knowing misrepresentations were material to Provident Life's issuance of the policy. Accordingly, McKinney was well informed that his answers to questions 6 and 8 would become part of the insurance policy he received, and thus were material to Provident Life's issuance of the policy. The application's particular inquiry into the applicant's prior treatment for memory loss, confusion, or speech disruption rendered those questions presumptively material. McKinney, of course, wanted the United States District Court to rewrite the policy and give him coverage, even though he lied in the application. But as the U.S.C. found, it is not the role of the court to rewrite the terms of the insurance agreement to conform to the newly disclosed facts. Given the strong weight of authority establishing the materiality of an applicant's prior medical history, subject to specific inquiry, as well as the fact that McKinney's answers were incorporated into the policy issued, the court concluded that his knowing misrepresentations were material. Thus, Provident Life was entitled to rescission of the insurance policy as a matter of law, and the U.S.C. concluded that rescission of the current policy was justified as a matter of law. In my opinion, this is a classic case of I didn't know the gun was loaded defense when a person intentionally shoots another. In this case, McKinney knew the true facts of his condition both during and after his cancer treatment and lied on the application he submitted to ERISA for disability insurance. He claimed the lie was innocent because he didn't know about the diagnosis, but the evidence reviewed by the U.S.C. established he was neither innocent nor ignorant. He just lied. Therefore, the court affirmed Provident's rescission of the ERISA policy as it should have. This video was adapted from my blog, Zelma on Insurance, available free to anyone at zelma.com/blog. It's also available on my Substack and at my locals community. If you found this video to be of interest or useful to you, please tell your colleagues about it so that they can also subscribe to the blog or join my locals community so that they can get these free blogs as well as the Excellence in Claims Handling program. Thank you for your attention.